Motion to enforce, y'all have announced for 3 hours. Does that remain an accurate assessment?
I think so, Judge. I'm hoping we can give some time back, but I guess we'll see.
Yeah, that should, hopefully we can.
All right. Well, Ms. Fatima will keep track of the time and make sure you each get an hour and a half. Unless y'all need to do anything first, I'm happy to hear opening statements.
Thank you, Your Honor. So I represent Eric Atkinson, the petitioner in this matter. And Judge, in a fairly short time period, there have been a fairly astonishing number of violations. The case kind of began in earnest with the MSA after 2 days of mediation with Kathleen Coble. There was an MSA signed on November the 3rd of 2022. It was Richard E. Gray IV who was representing Miss Atkinson, who had really done an exceptional job. He was discharged. Miss Atkinson refused to sign the decree, so it required an entry hearing, which we had Judge Hathcock sign the decree as we had tendered it. There was an arbitration provision in the decree as to Mr. Atkinson's personal property that had remained at the marital residence extensive list. It was to be arbitrated by February 15th back with Kathleen Coble. On February 15th, Kathleen Coble issued an interim award, and Ms. Atkinson, other than possession and access, virtually refused to follow anything in the decree or the arbitration award. So we filed the first motion to enforce. Specifically, there was a problem of Mr. Atkinson being able to communicate with his children. There was provision in the decree specifically addressing that, including the Children's Bill of Rights. And the parties have a 50-50 possession schedule. The pattern would be when the children are with Miss Atkinson, Mr. Atkinson cannot reach them. As we get closer to a trial, the calls improve. Trial comes and goes, he no longer can reach them. So that was one of the issues. There are a number of transfer documents for retirement accounts. The MSA, the decree said 50-50. We tried for ultimately it was a year to get the transfer document signed. That was part of that first motion to enforce. There was another provision in which Ms. Atkinson was required to follow the court-ordered. There was a psych eval court-ordered. Dr. Ainsley did, which included weekly psychoanalysis, and it included ongoing therapy sessions, and follow up with Miss Atkinson's psychiatrist. That was part of that first hearing as well. Miss Atkinson had hired new counsel. It was not Miss Locke. They filed what appeared to be a number of frivolous counter complaints. Judge Iserloh, at the conclusion of the hearing, held specifically the evidence showed that Maria Atkinson interferes with the children's communication with Eric Atkinson in violation of the agreed final decree. Judge Iserloh held that the shares would be divided 50-50, and specifically stated in bold, Maria Atkinson is ordered to sign the required transfer documents. There were about 6 of them, 6 different accounts meaning. This letter opinion was on October the 5th of this past year. Judge Iserloh replaced Dr. Ainsley's recommendations of weekly psychoanalysis with an updated recommendation by Mary Alvarez. Ms. Atkinson in the interim had hired Mary Alvarez as her therapist. Mary Alvarez did an updated report, and Judge Iserloh concluded that psychoanalysis was outdated and the methodology Mary Alvarez uses was more appropriate. Judge Iserloh ordered that Ms. Atkinson was to pay attorney's fees. And this is significant too. At the conclusion of the letter opinion, this was October 5th, Judge Iserloh specifically stated in bold, neither party frankly, based on the ruling, Miss Atkinson, because all of the counterclaims, again, had been denied. Neither party will be held in contempt provided that they are in full compliance with my order within 30 days after my signature on the order. After that date, fines and possible jail time may be assessed against a party in contempt. So the order memorializing Judge Iserloh's letter of opinion was signed and entered on October the 30th. In between October 5th and October 30th, Mr. Atkinson updated the transfer documents to accurately reflect the balances because of the volatility in the stock market. I began sending letters in mid-October. Let's get the transfer documents signed. There was two of them kind of mid-late October. There was one in November. The transfer documents were signed on January the 30th, almost 2 months after we had to file this instant action. Because of the time gap between October the 15th or 18th and January 30th, and again with volatility in the market, the numbers had changed on two of these accounts. One is 0469, one account is 8142. And so we have now tendered, am I going too fast?
We missed the numbers in the second account.
Okay.
It broke up in the middle.
Oh, I'm sorry, 8142. I do keep my eye on Michelle to see her doing this to me now and again, and so I try to slow down at that point. Because of the time gap, it's almost 2 months in signing them and the volatility in the market, those numbers have changed. We have again updated them last week. We again sent them on those last lingering two and said we need to get these redone for the follow-up this week. As for the attorney's fees, those were due. These are the court-ordered fees that Judge Iserloh had ordered Ms. Atkinson to pay. Those were due by the end of November. There was a check mailed in mid-December, cashier's check for those. There are still ongoing communication problems with the girls. You're going to hear testimony about how Ms. Atkinson's phones are constantly malfunctioning. And that, yeah, I believe is going to be their defense to this. There again is a pattern of calls work better when we get closer to a hearing. And when the hearings are not there, the calls virtually disappear. The order that Judge Iserloh signed also included personal property, Mr. Atkinson. It's been well over a year. There have been multiple attempts by Mr. Atkinson to either gain access or the like to obtain these personal properties, some of which are mementos. Mr. Atkinson's father passed away years ago, some of which are items his father had given him that are frankly irreplaceable. And he would like access, a date certain, a time certain, to go back to this house. It's called Magnolia, to retrieve his personal property. And the alternative, perhaps we could just put a value on these if there's a claim that they're not there anymore. So that's the personal property side. Now, it's important to note that the affirmative defense of justification was not pleaded. And there was defenses of lack of sufficient clarity and the like. But as far as any excuses for why they didn't do any of these things timely, those arguments are waived because there is no justification defense. Now, unfortunately, there's two other issues that have more recently popped up. The marital estate consisted of two real properties. A house that we refer to as Magnolia, which is a multi-million-dollar property in which Ms. Atkinson resides. There is another house called Cypress that we refer to as Cypress, and that's the house in which Mr. Atkinson resides. Mr. Atkinson pays 100% of the bills on both mortgages, taxes, everything. That was part of the deal, in which there will be a reimbursement upon the sale of these properties. The decree provided that the parties would immediately list these properties for sale. Mr. Atkinson contacted Ms. Atkinson in December of 2022 about signing listing agreements with Jacqueline Foreman, who is on the screen right now. She is their broker, has been their broker. And Miss Atkinson refused to sign the listing agreements. It was only until after we filed the first motion to enforce that Miss Atkinson finally signed the listing agreements, and she finally signed them. And I believe it was April, around the 8th. So this was 4 months after the mediated settlement agreement. There have been problems, and this goes back to Miss Atkinson and her claims with her phones. There have been problems with Miss Foreman being able to reach Miss Atkinson for weeks at a time on showings. There were showings, open house, in which one of the comments was we need to remove the dead bird from the walkway. There have been a number of cancellations of showings by Miss Atkinson. And there's recently been a significant water leak she was unaware of. Mr. Atkinson, again, because he pays the bills, got an exorbitantly high water bill. He figured out that there had been a water leak. That caused damage to the property, which has further reduced the value of that property. And so what we're asking for is a receiver to take over the sale, basically, and everything of Magnolia. The house on Cypress is an interesting story as well. That house is kind of bumped along with a really significant number of showings. There was a contract offer that was made on that house very recently by an independent third party. And the net to the parties after the fees, buyer's expenses, and the like would be $501,400. $501,400. So again, this is one of the houses in which the children live half the time. Mr. Atkinson, given that, and Miss Atkinson signed that contract. She was in agreement with a net of $501,400.
And that was a net that was to be divided between the two of them?
After the reimbursements due to Mr. Atkinson. And because there's going to be a dispute on that, because there's been a dispute on everything in this case, all of that money will be tied up until the resolution of the reimbursement claims. So what Mr. Atkinson did, because he doesn't want to move the children from this house, he made the same offer in which Jacqueline Foreman, who is again their trusted broker, she will receive the exact same commission. There are no buyer's expenses built in, and the net that Mr. Atkinson has proposed is also $501,400. It's the exact same. Significantly, Mr. Atkinson's proposal is that Miss Atkinson would receive distribution of the undisputed amount by a date certain, by mid-May of this year, just a few months away. So not the entirety of the money is tied up, only a part that is in dispute. So that is significant. The response to that was they have now filed a motion for receivership only on Cypress. I suspect they're going to ask that Mr. Atkinson be removed from Cypress. So that pretty well summarizes this case, that last point. And so what we're asking for, and I did submit a proposed disposition of issues, is we're asking, we had one other fact about the calls. The children have these little flip phones, which is, I'm sure, fine, but they're cumbersome. It's one problem. The phones tend to malfunction, is at least what Mr. Atkinson claims. And what we would like to have happen is to have them, their father uses Apple products, the mother uses Apple products. It does not have to be an Apple 15, but at least get them functioning compatible phones and allow them to access them, certainly parental controls and the like, but at least be able to access them freely to communicate with their father. The 8142 and the 0469 updated transfer documents we'd like to have signed immediately. There still is no evidence that Ms. Atkinson has gone to follow up with her psychiatrist after a year. We would like to have some sort of confirmation of that. We'd like to have a date and a time certain for Mr. Atkinson unencumbered to go retrieve the list of items that we have attached. We're again asking for attorney's fees. The Judge Angelo could not have been more clear in her order. Put it in bold, put it as a separate paragraph. This needs to be done within 30 days. The transfer documents were 2 months after we filed the new motion to enforce. The attorney's fees were way late. The calls are still a problem. He still has not seen one item of personal property. So that is our case, Your Honor.
All right. Thank you, Mr. Turner. Ms. Locke.
Thank you, Judge. I understand that as Mr. Turner's perspective, and Mr. Turner's been involved in this case a little bit longer than I have. I came in after Ms. Atkinson's prior counsel, and I'm not going to comment much on that other than Ms. Atkinson has now signed the TIDs that were required, but was interested. And so let me back up a little bit. One of the arguments was about, and you're going to see, Judge, the biggest problem with this case is the underlying drafting of the divorce decree that has allowed all of these problems to occur. There is nothing in the decree for terms relating to the sale of the residence. You're going to see that Mr. Atkinson has refused showings on the Cypress Knee, that Miss Atkinson has refused a couple showings on the house that she is in. There's games being played by both sides on this with regards to showing. So for Mr. Atkinson to come in and say it's just Miss Atkinson that's having these problems would be an inaccurate representation of what is occurring. What happened most recently was we had a bona fide offer for the house that Mr. Atkinson is in. And he doesn't want to have to move and figures, okay, well, I'll sign this contract or he refused to sign the bona fide contract, which he should have done. You're also going to hear testimony from the realtor herself, because I have the realtor here to testify. I have Dr. Alvarez here to testify, and I have Ms. Shaw, the children's therapist, here to testify today to tell you what is actually going on. Sorry, Ms. Williamson, I'll slow down. And what you're going to hear is that the children are very clearly indicating to their therapist that they are not having any problems communicating with either parent, that occasionally their phones don't work while at mom's, but that they're not hindered from talking to dad. Not only that, you're going to hear testimony from the therapist that the children indicate they are encouraged to call their dad by my client. The decree doesn't require a specific type of phone. We keep adding more and more burdens onto the woman who doesn't make any money, which seems to me a form of financial abuse, which I think you'll hear from Dr. Alvarez is a real concern about what's going on with Mr. Atkinson versus Miss Atkinson.
Let me stop you for a second and ask you how old the children are.
Judge, they're born in 2011 and 2015. Bianca is going to be 13 and Gianna just turned 9. And we have phone records, Judge, to show that they are in fact talking to dad, but you're going to see there's not a whole lot of calls coming in from dad. So Judge Eislow already dealt with some of those issues. And I think the court is aware that the enforcements, in order to find someone in contempt, have to be very, very specific in order to have a person held in contempt. And I'm going to go a little bit backwards. You're going to hear from Dr. Alvarez because they say that but one of their allegations and violations is that my client does not follow the recommendations from Mary Alvarez. Well, those, number one, her recommendations are not specifically delineated in any order for the court to know what it's referring to enforce. So we do not believe it should be held in contempt. Furthermore,
You're going way too fast.
I know. I'm sorry, Judge.
I can't follow you, and neither can Miss Williamson.
All right, I'll slow down. You will hear from Dr. Alvarez that in fact my client has followed her recommendations, that she engages in weekly therapy and does what she is required to do. We'll ask the court to take judicial notice of the orders in this case, because that's what the court's really going to have to look at. While Mr. Turner is correct in the fact that there is bolded letters that says neither party will be held in contempt, provided the parties are in full compliance with this order within 30 days after signature on the order. And the court will see how this is drafted. That applies to the enforcement provisions relating to phone calls and relating to the contact, as well as some other issues on the violations. That particular bold paragraph, and I can share my screen, comes before the attorney's fees section. There is no due date on the attorney's fees section in this order. And how this order is drafted states that this provision, and if you look at the normal interpretation of it, would apply to everything that is above it, not the attorney's fees. And the court, as Mr. Turner's already testified to, has already indicated that my client has paid it. And in fact, it was paid in December via certified check. There is not a disagreement,
When you
Judge.
said had paid it, you mean the attorney's fees?
Yes, Your Honor. The attorney's fees have been paid and we believe based on the draft, the order, that she is not in any violation of the court order with regards to those fees. Furthermore, if the court does find that somehow the order applied to paying the attorney's fees within 30 days, our belief is it's not specific enough to be enforced by contempt. That being said, the fees have been paid. We cannot disagree, Judge, and I'm not going to disagree that she didn't sign some of the transfer documents within the time that Judge Iserloh required. I was able to finally sit down with Ms. Atkinson and explain to her the documents and got them signed and sent back to Mr. Turner. Both parties, Judge, have asked for a receiver. And I honestly don't think that a receiver should be appointed on either side. What Mr. Atkinson did in this case was said, here's my counter offer on the Cypress Knee house, which is the house that he resides in. But here's my offer, but here's also my offer on what the proceeds should be out of the Magnolia house. Like he was trying to make one contract contingent upon the other. And that's not what the intent of the decree was. The intent of the decree was that these properties were to be sold to third parties. If the intent of the decree was something else, then it would have been delineated in the decree.
But why does that matter to your client, Ms. Locke? If he matched an offer, why is that a problem?
Because it wasn't exactly a matching of the offer. One of the giant fights we have, Judge, and you will see from the drafting of the decree, and I'll pull it up for the court, relates to deductions for the house and how, and I don't know if I'll share my screen again, Judge. So this is the real property provision relating to the sales of both of those residents. Okay. And that is it. There are no other provisions that control this. What you will find, and you'll hear from the realtor, is that Mr. Atkinson was advised that he should reduce the price in the house. He said no. And so what we have is someone that's continually trying to play games to his advantage because the market's depressed right now. If a receiver is appointed, we're not going to capitalize on the market. This will start the increase, which will start end of March. Sorry, Ms. Williamson. The market is about to start increasing. We all know that the selling season is end of March, starting in April, and continues through July. And he is trying to, I think, lowball and reduce the amount of monies that Ms. Atkinson's going to get. We are going to be back in court on how we split the proceeds because proceeds were not defined in the underlying order. Half of the problems.
Let me just stop you because I'm confused.
Yes,
you said the market is depressed and he refused to decrease the price, but now you're saying he wanted to decrease how much she gets, which if he's not willing to decrease the price, how does that decrease what she's getting?
So let me back up. We've been to mediation a couple times since I came on this case trying to get somewhere on some of the items that were unresolved. Before we went to mediation, Mr. Atkinson had refused to reduce the price on the house because he said, well, let's just wait to get to mediation. We'll take care of it all. Then the realtor comes in and makes recommendations on what she thinks the values of the house to sale should be listed at. And I don't even think we're at that listing price currently. So yes, the market is depressed, but I believe that Mr. Atkinson is going to try and come in lowball offers with a receiver so that he can maximize, I guess, maximize his profit and minimize what Ms. Atkinson gets with the appointment of a receiver because the costs associated with a receiver are so expensive. We don't believe there should be a receiver. I believe both parties should work towards getting the house sold with the realtor, which is why I've asked the realtor to come testify today. Because I figured the court would like to hear from the other people that don't have a vested interest in suing each other after a divorce. But we just don't believe she should be held in contempt. We don't believe there should be any more attorney's fees. And we believe that we should just proceed with some additional instructions from the court on how to proceed with the sale of the residence. One last thing, Judge, as the personal property, there was some issues relating to what's supposed to remain in the house for staging purposes. I can, if there's other items, I will absolutely instruct my client to ensure that whatever items Mr. Atkinson wants that are not subject to staging requirements be turned over to him. It's not an issue.
All right. Thank you. All right, Mr. Turner, you may call your first witness.
Thank you. And let me clarify one thing, if I may. In our pleadings, we are not asking for contempt on the attorney's fees. There was a portion of Ms. Locke's opening that addressed that. All thanks to Mildred Fillmore, we do not have debtors prison. So therefore, we are not asking for contempt on the attorney's fees and never have been. With that, I will call Eric Atkinson. Thank you. And you have a divorce decree in this case, do you not?
Yes,
And it was signed by Judge Hathcock on January 6th of 2023.
that's correct. Yes.
Was it based on a mediated settlement agreement?
Yes.
What was the date of the mediated settlement agreement?
November 3rd, 2022.
Did Ms. Atkinson sign the decree?
No, she did not.
Was there a requirement for an entry hearing as a result?
Yes.
And is that what led to Judge Hathcock signing the decree?
Yes.
Did Judge Hathcock sign the decree as we had originally tendered?
Yes.
Did Ms. Atkinson follow the decree?
No.
Did that prompt an enforcement action?
Yes.
When was the enforcement action, the first enforcement action filed?
March of 2023.
What were the allegations, the violations alleged in the first motion for enforcement?
Significant challenges in communicating with our children while they were in possession of their mom. Specifically, she hadn't provided the communication devices to the kids in accordance with the decree. Alice would not cooperate with the transfer documents or the signing of the transfer documents for the retirement accounts. Numerous issues in obtaining my personal property and failure to comply with the psychological requirements outlined in the decree.
And did you prevail in that hearing?
Yes.
At this time, Your Honor, I'd like to offer Petitioner's Exhibit 1, which is the decision letter by Judge Iserloh.
I don't have an objection to that, Judge, but the order is what controls, not just that. But I don't know, it's an actual objection.
All right. Petitioner's Exhibit 1 is submitted.
Judge, I'd like, if you would please, to take judicial notice of the enforcement order, the October 30, 2023 enforcement order that's in the file that has been marked as Petitioner's Exhibit P2.
No objections.
All right. And actually, Ms. Locke mentioned in her opening that she wanted me to take judicial notice of all of the orders in the file, and I will do that.
And thank you, Judge. Our R2 is the actual decree. So I don't know if we want to just go ahead and admit that.
Is there any objection to that, Mr. Turner?
No objection, Your
And
Honor.
that's admitted as well.
So, Mr. Atkinson, on the letter that Judge Iserloh signed, the decision letter, you see this language that I've highlighted?
Yes, I do see it.
Okay, and that is at the bottom of the letter in regards to all of the issues that she found.
Yes.
Okay. Now, if you look at if you look at P2, it contains the same language, correct?
Yes.
So as part of the order, the court held that Maria Alice Atkinson interferes with the children's communication with you, correct?
Yes.
And so since this letter opinion has come out on October the 5th, how have the calls been with your girls?
The majority of the time, I'm unable to reach the girls when they are in possession of their mom.
So I've now put on the screen Exhibit P003. Can you generally identify this document?
Yes.
And what is this?
These are text messages from me to one of our daughter's phones. You know, I text them in the hopes to connect with them, and those texts are unresponded.
And this is a true and correct copy. Is that correct?
Yes, it is.
At this time, Your Honor, I would offer P3.
Judge, I'm going to object as all of these phone calls happened to the prior to the enforcement. Oh, I'm sorry. That's not correct. The enforcement was heard in 2023. So those are all fine.
All right. P3 is admitted.
So, Mr. Atkinson, it appears as if you text on a almost nightly basis. to your daughters, correct?
That's correct.
And then there's a gap between 9/12/23 and 9/22/23. Is that time gap when the children were with you?
I can't say for certain as I'm not looking at a calendar right now, but that's a safe assumption.
So I've now put on the screen exhibit P4. Can you identify P4?
Yes,
And just generally speaking, what is this?
this is just a schedule that shows days I'm attempting to contact the girls when they're in possession of their mom. Attempt of contact would be their text message or phone call, and then actual days in a given month when I'm able to successfully contact them.
And at this time, Your Honor, I would offer exhibit P4.
Judge, I'm going to object. It doesn't show the time he's making phone calls. It doesn't show anything of the specifics of the calls, the numbers he's called, etc., to be a valid summary of any attempts.
Your response, Mr. Turner?
Yeah, I just don't think the minutia detail is required for this. For the purposes that it's being offered, he's specified he tried to contact them in August 8 times, and this is how many times he reached them. And that's all this is attempting to be.
So on what basis did he compile them? What is the underlying information he used to put together P4?
Yeah, Mr. Ashton, how did you put together this chart?
I use the Verizon wireless phone logs.
Is Verizon Wireless your carrier?
It is.
And is it also the carrier? Okay, so at this point, Your Honor, I'd re-offer exhibit P4.
I'm going to object. If they're all using Apple phones, iMessages don't show up, and so it wouldn't reflect on any Verizon records messages going through iMessages. So it's not an accurate representation of what occurred.
So I guess I need to have that addressed, Mr. Turner.
I have no idea what you just said. I'm an Android guy, so I have no idea what that is. I do know that Mr. Atkinson has testified and complied with the authenticity statute, and in which it is what it purports to be, and he did the underlying foundation. And if she would like to cross-examine him, I'm happy for her to do so as to what iMessages do and don't do.
Well, I also,
All right.
sorry.
So I'm going to admit petitioners 4, and I do think it goes to the weight and not to the admissibility, and you're welcome to cross-examine him
Thank you,
on
Judge.
how he came up with these numbers. You may ask the next question, Mr. Turner.
Thank you. So the document speaks for itself in that in August, out of 8 attempts, you only had 2 successful contacts, correct?
That is correct.
And that tends to be the pattern until the case gets set for a hearing, right, in December?
That's correct.
And so now the pattern continues that the calls have improved since we've set the matter for a hearing, correct?
That is correct.
Was this the same pattern that happened last summer?
Yes.
Is your belief that, and your experience, that the girls can reach you when they're with their mother?
Sometimes.
So what are you asking the court to do when it comes to the phone calls?
I would like the girls to be provided with equivalent devices that they have when they're in my possession. The reason being the phones they've been provided don't really allow them to adequately text or communicate in the methods that they predominantly use. I'd like to ensure that the phones that are being provided to the girls are with a trusted and reliable telecommunications partner like an AT&T or Verizon. I would like to ensure that the girls have redundant charging devices for their phones. And I would like there to be oversight of the communication between a mutually trusted third party. Potentially that could be Michelle Shaw, the children's therapist.
So have you tried to just have it where you have one phone for the children and they take the phones back and forth?
I tried to do that before the decree was signed. And when I provided the girls with devices that they would take to their mom's house, those devices would come back not functioning correctly.
Were there also allegations that you had hacked into Miss Atkinson's stuff?
Yes.
And was there a forensic involved because of that?
Yeah, the court ordered a third party called Flashback Data to analyze all of the technology.
And what was their finding?
I'm
They
gonna
found
object
no
this to,
evidence.
I'm gonna object this to hearsay.
Sustained.
Let's turn our attention to the retirement accounts. There were a number of retirement accounts that were in dispute at the last hearing, correct?
That is correct.
And the judge at the last hearing, Judge Isolo, did order that Ms. Atkinson sign the transfer documents.
Yes.
When did you start sending transfer documents to Ms. Atkinson?
January of 2023.
And were any of them signed prior to the first enforcement hearing?
No.
The decision letter was on October 5th and the order was on October 30th. Were any of the transfer documents signed in October?
No.
Were any of the transfer documents signed in November 2023?
No.
How about December 2023?
No.
And were any of the transfer documents signed in January 2024?
All but one was signed on January 30th of this year.
Which one was not signed?
The Janney account ending in 8142.
I'm sorry, the what account?
Janney. Janney,
Thank you.
you're welcome. So I've now got exhibit P7 on the screen. Can you generally identify this document?
Yes.
And what is this?
This is a account value overview of Janney account ending in 8142.
And is this your account?
Yes, it is.
Is this a true and correct copy?
Yes, it is.
At this time, Your Honor, we'd offer P7.
No objections.
P7 is admitted.
Thank you, Your Honor. And we also show you P8. Can you generally identify exhibit P8?
Yes.
And what is this?
This is the transfer document for Janney to transfer Alice's portion of this account to her.
Your Honor, this is on, are we on YouTube or the like right now?
We are.
Okay. I'm going to need to pull that document for a second. I do need
Yeah,
to
to the extent that you have documents that include social security
Right.
numbers or anything else that's confidential, you either need to redact them or
Right.
we need to go off YouTube briefly while you discuss them.
Okay. Can we go off YouTube briefly while we do P8?
That's fine.
So let's address the personal property. There was an arbitration in February of last year, correct?
Yes.
And Kathleen Coble conducted that arbitration.
Yes.
Did she enter a interim award in February of last year?
Yes.
Is this a true and correct copy of that interim arbitration award?
Yes.
At this time, Your Honor, we would offer exhibit P12.
No objection.
All right. P12 is admitted.
So, Mr. Atkinson, what was the process of you getting, let me put that back up for a second. What was the process while I'm doing that of you obtaining your items?
The arbitrator outlined a specific instruction for us to schedule an opportunity for me to go to the home and collect my belongings.
And is this exhibit A 55 items?
Yes, it is.
Is that what was awarded?
It's what was awarded in the arbitration.
So this was over a year ago. Of those 55 items, which of those have you been able to retrieve?
I can't explicitly respond to that here. We do have another exhibit of all the items I've not been able to collect, both from this award and what was awarded in the divorce decree.
So did you follow the procedure Ms. Coble had outlined?
I did.
If you could look at exhibit P12A,
Yes,
are these our family or emails, excuse me, exchanges with Ms. Atkinson about following the procedures?
yes.
At this time, Your Honor, I would offer Petitioner's exhibit P12A.
I don't have any objections.
P12A is admitted.
So did you select the dates as you had been prescribed in the arbitration award?
I did.
Did you tender those to Ms. Atkinson?
I did.
Did she respond?
She did not.
So then did you pick the one date as had been prescribed in the arbitration award?
I did.
Did you send that to Ms. Atkinson?
I did.
And she did ultimately respond, did she not?
She did.
And after the expiration of the times in the arbitration procedure, she wrote, "I'm sorry, I will not be home and the home will be locked. I did not agree on a day and time with you." Correct?
That is correct.
So have you compiled a list of items as to what you have tried to do, what is there, what you have obtained? Have you done that?
I have.
And how did you do that?
I simply took the list of items that had been awarded to me and then notated what I had been able to obtain versus what I had not been able to obtain.
And is that contained within exhibit P13?
It is.
At this time, Your Honor, I would offer exhibit P13.
No objections.
P13 is admitted.
Has this list in the last week or so been sent to Ms. Atkinson?
Yeah, I instructed you to do that. Yes.
And have you received anything from that?
No.
So what has Ms. Atkinson told you about some of these items?
What? I'm sorry. Can you restate the question?
Yes. Has she relayed to you in the past that you can't find them or they're gone or the like?
Yes.
If you look back at P13 and down here on line 30,
Yes.
it says Mont Blanc pen.
Yes.
And had Ms. Atkinson previously told you that she couldn't find that? Or it was gone?
What she told me was that she couldn't find my office pens.
Okay, so it would be the Mont Blanc and the two cross pens.
There's a number of other in there too, but yes.
And so she made it clear that she did not have nor could find any of your pens.
That's correct.
So when we were at the last hearing, what did you see?
Alice was explicitly using one of the distinct pens from that office supply set.
So let's go briefly to Dr. Alvarez. Okay, so Dr. Alvarez, that is Miss Atkinson's current counselor, correct?
That's my understanding, yes.
So if you'll look, this is P14, and this is Dr. Alvarez's updated report. I'm going to offer exhibit P14, Your Honor.
I'm gonna absolutely object. And if we're not talking about what's in this, we need to please go off YouTube.
All right. Let's,
We are now live.
all right. And I believe you all wanted to take, Ms. Foreman out of order.
Yes, please, Judge.
All right, let me, ask her to turn on her microphone and camera.
If we can't get it to work in a few minutes, Judge, I'll just let Mr. Turner just take over. I don't want to waste my time. It's
All
not-
right.
not
She
very-
she might want to log out and log back in. Sometimes that works.
I'll
So-
get Juan to get with her. Thank you, Judge. We can just allow Mr. Turner to continue.
Yeah, she just needs to look at all the various places where she could turn the sound on and make sure she's got the computer sound and it's turned up.
Thank you, Judge.
So, Mr. Atkinson, the P14, which was admitted solely for the purposes of the recommendations. If you'll see recommendation number 3, Ms. Atkinson shall continue to follow all treatment recommendations by her psychiatrist concerning the medical management of ADHD. So have you received any information
Yeah,
ever about psychiatric follow-up?
No, I've not.
Great.
Well, it was.
I did not question because we had a video interviews from. another-
Ms. Foreman, we can hear you now. Ms. Foreman?
Yes, I'm so sorry.
No, we can hear you now.
Okay.
So I think let's go back to her, Miss Locke, and then Mr. Turner. You'll have to start over again because the noise with all of that blocked us from hearing what was
Ms.
happening.
Foreman, can you tell the court briefly how you know the parties in this case?
Yes, I was their real estate agent when they purchased their first home in Belvedere on Magnolia many years ago.
And are you the current listing agent for Cypress Knee and Magnolia? Is it Magnolia Cove?
Yes, I am.
Okay. And can you tell the court basically a summary of what's gone on since you started listing those houses? And let's start with Cypress Knee first.
Okay. I guess we started talking last year before let's see, last year, like in April or May, about putting these houses on the market. Went out there like I do with all my listings and determined the things that needed to happen as far as, getting the house prepped to go on the market, whether that be painting, landscaping, just whatever needed to be done. We had several tradespeople come out there to determine that.
So, Ms. Foreman, Ms. Williamson is the court reporter, and she is trying to make a record of everything that's being said here.
Mhm.
And she is certified to 250 words a minute, and you're speaking more quickly than that. So I'm
Okay.
going to ask you to work on your speed and also keep an eye on Ms. Williamson. If you see her shaking her head no, that means you're going too fast.
Okay.
And I'll direct you a little bit, Ms. Foreman. When were the houses finally listed, if you can recall?
Goodness, I can look it up real quickly if you'd like.
If
I mean,
you
I've got several listings. I just don't know off the top of my head. I want to say that Magnolia's been on the market around almost 300 days. Cypress Knee less than that. I would say about half the amount of time on that one.
Okay. And Mr. Atkinson is living in Cypress Knee, is that right?
That's correct.
And Miss Atkinson is living in the Magnolia Ridge house.
That's correct.
Have you made recommendations on the Magnolia Ridge house with regards to pricing?
Oh, absolutely. Yeah.
Okay. And has Miss Atkinson tried to follow your advice on the listing price for Magnolia?
Yes. It took some time, as with so many sellers wanting to, still believe that we're in that market that was so escalated in pricing. So as with many sellers, it really took some time to realize that we're not in that market anymore, that we've definitely normalized.
Okay. And has Mr. Atkinson complied with your request to modify the house listing price on Magnolia?
Yes.
Okay.
I mean, yeah.
Was there initially a problem with him refusing to agree to reduce the price on Magnolia?
Gosh, I've never been in a court situation like this, so I don't know if I'm just supposed to answer that question or if I'm supposed to be more broad about it.
If you've just answer my question. If you've any question, if you don't understand my question, I'm more than happy to rephrase. What was the house originally listed at, if you recall?
$2,050,000.
Okay. And what is the current listing price?
$1,850,000.
Okay. Have you made recommendations to have it removed from the MLS to relist it?
Not since I finally have a price reduction.
Okay. And who was the holdup in that price reduction?
For a long time, it was both of them, but then it seemed like that was the only thing they could agree on, is not changing the price.
Okay.
And then now we have Alice I would say, came to terms with reducing the price first, but then, obviously they both came and agreed on the new price that we have now.
Okay. And have there been any offers on Magnolia Ridge?
There have not, except for the one that Mr. Atkinson made.
Okay. And what, and have you done a market analysis on that house, the Magnolia Ridge?
Many. I've done
Okay.
many. Lots of market research, lots of explanations of why the pricing was not correct.
Okay. And only because I don't know this, but is your market analysis going to change once the selling season hits?
No.
Okay. And what is your estimate? What is your market analysis of what that house should sell for?
It's still at the 1.7. I mean, I've gone at different approaches on this, as I do with all my clients, especially as our market is normalized, using a few different techniques. One being, if we just take when you purchase the house and give it a 6% appreciation rate up to today, which is a good appreciation on real estate in Austin, Texas, that puts it at about 1.6. We're still bumping it up to 1.7 because getting into this particular neighborhood under 2 million is there's not a lot of houses like that. So we gave it even more value on that, more of an appreciation. However, it stands out a little bit different than many of the homes in that neighborhood.
And how so?
And let me just stop you and ask you, which house are we talking about now?
Magnolia Ridge.
Magnolia.
And that is the one that Miss Atkinson is living in?
That's correct. Trying to get y'all.
Okay.
All right. And I'm going to share a screen. You have produced, because there's been an issue in this case regarding who's refusing to do what on showings, right?
Mm-hmm.
Is that a yes?
Yes, it is.
All right. And this is one of the printouts you've done with regards to Magnolia Ridge. Is that right?
I'm sorry. Could you say that one more time?
Sure. This is one of the printouts you have provided to us regarding the showings on Magnolia Ridge. Is that right? I can make it a little bit bigger.
Yeah, thank you. I'm off my big screen. I'm not sure if I gave that to you or if it's just something that, they both have access to our showings and they both have access to, who says that they can come in but yeah, it looks like it.
Okay. So
it came off one of my sites. Yes.
Okay. So this shows, at least for a period of time, showings, declined showings, canceling showings, who's canceled them, etc.
Looks like that was, that's correct at that point. Mm-hmm.
Okay. And have you found you've had any real issues with Miss Atkinson in showing the house?
Not as of recently. No.
Okay. And when was as of recently?
Just the past several months. It's been a lot easier to show. It was just in the very beginning. I think it was just trying to get the footing on how everything worked. And it was just in the beginning that was difficult.
Okay. Judge, I move to introduce R23.
No objection, Your Honor. That's also our P21.
All right. R23 and P21 are both admitted.
I'm going to show you what's been marked as R24. And this is the same printout for Cypress Knee, right?
Mm-hmm. Yes.
Is that a yes?
Yes.
And it shows, and that's where Mr. Atkinson resides, correct?
That is correct.
All right. Judge, I move to introduce R24.
No objection.
R24 is admitted.
And this shows a fair amount of canceling by Mr. Atkinson on the showing of the Cypress Knee residence, doesn't it?
It does. I just want to say when a time doesn't work specifically for either seller and they need to reschedule it, it says decline, and that's asking the agent that's trying to show to try another time.
Okay. And so it is reasonable for a person that is selling a house to decline a showing. Is that right?
Yeah, it happens.
Okay. I'm going to go back to R23. And so decline showings could be the same. Is that right?
That's exactly correct. A decline means I'm giving you the opportunity to try a different time. Usually when that happens, either one of them would call me and I'll call the agent and say, hey, this couldn't show for whatever reason. Is there another time that works?
Okay. And Miss Atkinson has actually reached out to you when she accidentally declined a showing. Do you recall that?
I do recall that.
And can you tell the court what, email correspondence from you to, my client back in September of 2023, is that right?
Oh, yeah. Can you make it a little bit bigger? I'm sorry. I'm
I
on my
sure
laptop
can.
right here. Okay. So what is the question?
Well, that's your email to her, correct?
It is. Mhm.
All right, Judge, I move to introduce R19.
No objection.
And this,
Hang on. R19 is admitted.
sorry, Judge. And this shows that on September 3rd, 2023, there'd only been one decline showing by my client at that time. Is that right?
I believe that is correct.
Okay. Was there a valid offer on Cypress Knee recently?
Yes, there was.
Okay, can you tell the court about who the offer came from?
Ingrid Mendoza, I believe is her last name. It was an agent buying for herself.
Okay, and did Miss Atkinson sign the contract for that sale?
She did.
And did Mr. Atkinson ever sign it?
No,
Okay. And how many days were you able to keep that offer open to try and get Mr. Atkinson to sign?
over a week.
Okay. I'm going to show you what we've marked as R25. And this is the email that you sent to them regarding the actual offer on Cypress Knee.
Mm-hmm.
Is that a yes?
Yes, I'm sorry.
Okay, Judge, I move to introduce R25.
No objection.
R25 is admitted.
Okay. And did Mr. Atkinson ever give you a reason why he refused to sign the contract for sale?
Well, we had a counter. I mean, he had a counter, and I countered to the buyer's agent either by email or verbally. They revised the offer to match those terms. And no, I'm not exactly sure. I got an email saying that it was going to be signed, and about 30 minutes later was told that it would not be signed.
Okay. And I'm assuming that sale has now been lost.
It has. I reached out to him recently just to actually, apologize again and say thank you for being so kind. And I felt bad for them, and they were indeed under contract with a different property.
Okay. And Mr. Atkinson actually made his own offer on Cypress Knee. Is that right?
That's correct.
Okay. Did it match the sales price of what was offered from the other contract?
I don't exactly. I think there was two different offers. I don't remember the first one this exactly, but the second one that he just revised, the proceeds that would go to Miss Atkinson's did seem to be within a couple $100 of the same.
Okay.
The only real difference was the contingencies or the addendums that had to go with it for buying out Miss Atkinson's. It was going to take a little bit more time.
Okay. And what was the projected close date on the other contract, if you know?
The first one?
Yes, the one that Mr. Atkinson refused to sign.
It would be closing, I think, in just a couple of weeks or a few weeks from right now.
And so it would close much sooner than what Mr. Atkinson had proposed in your experience.
Yes.
Okay. Pass the witness, Judge.
So on Magnolia, you had mentioned that there had been some repairs that you had recommended be done. Do you remember that?
And a year ago or so? Mhm.
Yes, ma'am.
Yeah,
And Mr. Atkinson did all of those, correct?
he did.
And he paid for those, did he not?
I believe so, yes.
And same with Cypress. He made all the recommended repairs that you had requested, correct?
I would say most of them, yes.
Okay. So from Miss Mendoza, and this is
Yeah.
exhibit plaintiffs or petitioner P16. Is this that contract?
Yes, sir.
I'll show you. This one is the 544,000.
Mm-hmm.
That'd be yes for the record.
Yes.
Okay. I'd like to offer P16.
No objections.
P16 is admitted.
So it's 544,000. Now this has Miss Atkinson's signature, correct?
Correct.
So if you'll, if we go to the 5th page, it's going to close March the 15th, right?
Mm-hmm.
And that'd be yes for the record?
Yes.
Okay. Now there's on paragraph 12, there's a provision down here that talks about $10,000. You see that?
Correct. Yes.
So that actually comes off of that 544,000, does it not?
Correct.
And then there was a commission to you, and there was a commission to Miss Mendoza,
Yes, sir.
right?
Yes, sir.
And this is 3% each.
No, 2% to me, 3% to her.
Okay. So I had calculated probably incorrectly that the total commissions, broker's fees would be $32,600. Does that sound about right?
That sounds correct.
So that would be 16,300 to you, and I had it at 16,300 to Miss Mendoza. Does that sound
Well,
about right?
No, because one would be for 2% and one
Okay.
would be for 3%.
So it's a touch off.
I'm sorry.
So if you'll now look at P17, this is the offer that Mr. Atkinson sent, correct?
I think so. Can you go back up?
Yeah, I'm sorry. This is actually the addendum. So let me get
Yeah.
to
Okay. There's the addendum.
of it.
All right.
That's the loan assumption addendum. So there we go.
A hard time, Mr. Turner, making a record because you're both speaking at the same time.
Okay, I will try to do better. Sorry about that. Is this the contract that was offered?
Can you go down a little bit, please? And let me see the sales price is correct.
Okay,
I'm sorry,
I'd
this
like
is the contract that's offered on Cypress by whom?
by Eric Atkinson.
Okay.
And so I would offer exhibit P17.
No objections.
P17 is admitted.
Okay, so the contract price is 517,680. See
Yes.
that?
Yes.
Okay. And there is no provision for the the $10,000.
That's correct.
And on this one, if you look at the special provisions, so this states that the undisputed portion of the proceeds shall be distributed on March 14th. Now that's actually the day before the other closing, correct?
Mhm. Yes.
Right. And this is the undisputed portions will be distributed to Miss Atkinson on the 14th. Right?
Yes, I do. I see that. Yes.
And then it goes on to say that this loan assumption will not occur until later, but Mr. Atkinson will indemnify Miss Atkinson until the closing, right?
Yeah, I just have to say that in this special provisions that is usually used for attorneys, it's a little bit over, my understanding. So that's something that you guys would have to explain and understand. And I don't understand what the undisputed portion actually means.
And then the last thing, I'm sorry, I thought you were finished.
Go ahead.
Then the last thing under special provisions is it ensures that your broker fee will be the exact same.
Correct.
And actually, since you were only going to take 2% before, this is higher broker fee, turns out, because of my math mistake, it sounds like.
I'll have to get my calculator out, but it looks close.
So both of these net the parties before the underlying loan and the title closing costs and things like that. It nets each person almost the exact same number, right?
That is correct.
And this contract by Mr. Atkinson actually funds money to Miss Atkinson sooner.
That's what it looks like to me. I will say when I presented this offer to Alice that I instructed her to take directly to her attorney because I am not privy to the information and special provisions. I don't know what the undisputed portion is. So I told her, give this to your attorney and you guys work that out because I don't understand exactly how that's working.
And Ms. Atkinson rejected this contract offer by Mr. Atkinson, correct?
I wouldn't say rejected. I thought she gave it to her attorney. She told me that her attorney was responding to you guys, but from what I learned from Mr. Atkinson, that y'all had no response. So
Correct. And you certainly have not gotten a signed contract from Ms. Atkinson.
no.
So back to Magnolia on the, and this is RP 21. There are a number of canceled showings by Miss Atkinson, correct, that are highlighted here?
Yeah, I believe that possibly could have been the same person. I just can't remember in October.
And then on Mr. Atkinson's on Cypress, before he tendered his contract offer, there was one cancellation, and that was during the holiday season on December 21st, correct?
Do you mean the whole time it's been listed?
Correct, based on that sheet.
Let me just, Magnolia is there. And you're asking me about Cypress. That's not what I'm looking at.
Right. So let me ask you a couple more things about Magnolia.
Mhm.
There were problems with the showings as far as, for instance, somebody commented there was a dead bird and that needed to be removed, right?
Yeah, that was I think I was having surgery that morning. And so I had one of my associates be at that. It was a property tour of a house, of several houses in the area. And yes, there was that morning, I guess a bird had, I don't know how it died, but someone had said, yes, that needs to be removed. I don't think anybody was aware that the bird was there until that morning.
And I have on the screen now, exhibit P25. This is a text that you sent to
Mhm.
Mr. Atkinson, correct?
It is.
And this was in October of this past year.
Yes, sir.
Is this true and correct copy?
Yes, sir.
Am I offered your honor at this time at Petitioner's Exhibit 25?
Okay, no objection.
P25 is admitted.
So in P25, you have contacted Mr. Atkinson and said you have not been able to reach Alice in a couple of weeks. Concerned about her, that you basically had somebody go by to do what I'd call a well check.
Well, no, that one of my friends who's also a realtor was showing a house in the area, and she drove by. She just happened to drive by, but I was concerned. Yes, I was concerned because I would never reach out to one or the other about the other one, except for out of real concern. And I let Alice know that I had reached out to Eric because I was definitely concerned about her.
And there have been other times in which you've had difficulty reaching Miss Atkinson as well, correct?
For a period of time. Yeah, nothing like this.
I'll pass the witness. Thank you, ma'am.
No other questions, Judge.
All right. Thank you, Ms. Foreman. You're welcome to go ahead and log off.
Thank you so much.
Now we're going to go back to Mr. Atkinson, and I believe you were questioning him, Mr. Turner.
Thank you, Your Honor. So, Mr. Atkinson, what would you like the court to do as it relates to Magnolia? And what are the problems you perceive with Magnolia's sale?
Well, the problems that I perceived with the Magnolia sale were not just price. They were communication and collaboration with Alice. I was concerned about the declined and unresponded to showings. I was concerned about the open house feedback. And I'm more recently concerned about the maintenance of the home, as we've had some maintenance issues with the house.
And what maintenance issues are those?
I received a water bill for the home in October. It indicated water usage in the home was 5 times any previous usage, and was the largest water bill that I'd ever received on the home.
And what did you determine?
There was a leak. The leak under the courtyard porch.
Did that leak? And this was a leak at Magnolia in the home in which Miss Atkinson lived.
That's correct. It was not in the home. It was outside the home. So it was exterior plumbing, but directly in the courtyard porch area.
Did you go out and inspect it?
No, sir.
And do you know if it has caused damage?
Yes, it has.
What damage is that?
The framing of the deck is rotted.
And what is it you would like the judge to do as it relates to Magnolia?
Appoint a receiver.
And as far as Cypress, what would you like the judge to do as far as Cypress?
I would like to be able to tell my children that they don't have to move, and I would like to have my offer approved.
Before I need to re-ask this question, have you received any information about Miss Atkinson going to a psychiatrist at all?
No, I'm not.
In the entire year since the decree, have you received one piece of paper?
No,
And who's paying for the Magnolia mortgage?
I pay all expenses for Magnolia, including the mortgage.
And so does Ms. Atkinson pay any expense for Magnolia?
No,
And how long has that arrangement been in place?
that's been since I filed for divorce.
So that's been for 2 years. She has lived in a $2 million house without paying a penny.
That's correct.
I'll pass the witness.
All right, let's just talk about phone stuff first. I'm going to show you what has been already entered into evidence as a final order. And this is the order from Judge Iserloh. You correct that? You remember that?
I do.
Okay. And Judge Iserloh says that my client shall immediately provide separate electronic devices to each child and shall allow the children to communicate with Eric Atkinson in compliance with the agreed final decree of divorce, correct?
Correct.
Okay, you'd agree with me that she's provided 2 separate electronic devices.
I can't fully agree with that because it's been reported to me that the devices don't function often.
Okay, so did you understand my question? Let's start with your children. Does Bianca have an electronic device that's been provided by her mother?
She does.
Okay, so does Gianna have an electric device that's been provided by her mother?
She does.
Okay. Let's go look at the decree of divorce. This has already been admitted as R2. And this is the provisions relating to your ability to communicate with the children, correct?
Correct.
Okay, and you would agree with me that it says both children will be provided electronic devices at each house to allow and enable the children to communicate with their parents, and the children will not take the devices to the other house, correct?
That is correct.
Okay, and so you are alleging that she has not complied with this now, is that correct?
Yes.
Okay, and so you are allowed to communicate with the children, correct?
Sometimes.
Okay, well, tell me this. Is there an actual schedule in here in which you are supposed to talk to the children?
No, we attempted to put together a schedule when we did co-parenting with Michelle Shaw, but
Okay, but you'd agree with me, there's no court order that delineates time periods in which you are to talk to the children, correct?
correct.
And you would agree with me that the children's therapist has indicated to both you and Ms. Atkinson, the children have not expressed that either parent is denying access to either parent on communication devices, correct?
Well, if I provided my child with a phone that did not.
Objection, non-responsive. Good,
Sustained.
thank you. Did you understand my question?
Please restate the question.
Sure. Did Dr. Shaw indicate to both parties, you and Ms. Atkinson, that the children have expressed there's been no issues with parents prohibiting communication to the other side?
I have heard that from Ms. Shaw. Yes,
Okay, and you'd agree with me, she sent you all a letter regarding that, correct?
she did.
Okay, and I'm actually going to show what has been marked. It's your exhibit is P6. And Judge, I'm going to move to introduce P6.
Any objection?
No objection, Your Honor.
P6 is admitted.
Thank you. And so this is the letter written by Miss Dr. Shaw that indicates that the kids have both clients report not having a phone number for their mother and are doubtful the mother's device would work. You recall that?
I do.
Okay. And are you aware to all the lengths that Miss Atkinson has gone through to try and get her phone to work consistently?
No,
Okay. And so you really have no knowledge of what all the attempts she's gone through, correct?
no. I mean, I've heard some of it, sure, but I don't understand the details.
And Dr. Shaw says both girls have reported in sessions that their mother allows them to call their father, right?
Yes,
Okay. The girls have both made statements that my mom wants me to let you know that I can call my dad, right?
I've heard that. Yes,
And both clients report that on occasion their mother has reminded them to call their father, correct?
yes,
So it would appear, based on at least the other professional in this case, that they're allowed to communicate. Is that right?
yes,
Okay. Now you would agree with me that you can text them,
yes,
and they don't like the flip phones or whatever they have because they can't text in the same way they normally do, right?
correct.
And you're actually asking this court, so I want to make sure I'm clear. You're asking this court to order that they've got multiple charging stations for phones?
Yes.
And you're asking the court to require Ms. Atkinson to provide specific phones, correct?
Well, the type of phone that
Yes,
they,
it's yes or no?
not specific, no, but a category of phone is
Okay.
fair.
And what category of phone are you asking the court to order Ms. Atkinson to provide?
iPhone?
Okay. And are you willing to pay for that?
No.
Okay. So you want my client to incur additional expenses, even though the underlying order that you agreed to doesn't require so, correct?
Yes.
Okay. And you think you're being reasonable in your request, is that right?
Yeah.
Okay. So you had the ability to provide to either myself or prior counsel all of your underlying phone records, correct?
Yes.
And you did not do so, is that correct?
No.
Okay. And in fact, you compiled the spreadsheet that you made an exhibit, and we're just supposed to trust that you accurately represented without any of the supporting documentation, correct?
I'm delighted to provide you with my phone records.
Okay. And you don't include the time that you tried to contact, correct?
Not on the exhibit we shared, no.
Okay. And you don't put the method in which you tried to communicate, correct?
Not on the exhibit, no.
Okay. And you did not put any other identifying information that could help us further analyze whether that's an accurate, sorry, Ms. Williamson, whether that's an accurate representation of the records, correct?
Correct.
All right. Let's go to the mediated settlement agreement. Or switch quickly to property because I don't want to run out of time. You're aware that the divorce decree is based on the mediated settlement agreement, correct?
Yes.
All right. And you have said and produced to us TIDs that you want us to sign based on your calculations, correct?
Yes.
Okay. And you are taking your flat amount of the separate property without any losses or gains. Isn't that correct?
I've produced every transfer document for
Objection non-responsive.
exactly the same way.
Objection.
Sustained. Just listen to her question and answer it, and your lawyer will have an opportunity to ask you follow-ups.
Yes, Judge. Thank you.
And you have taken out your separate property deduction at a dollar amount, not taking into consideration losses or gains, correct?
Yes.
Okay. And you believe that you should not be subject, your separate property should not be subject to market gains and losses. Is that correct?
No.
Well, but that's how you've calculated it, right?
I've calculated them all the same way.
Okay. And you calculated it as one of the accounts as $150,000 that you deducted outright, correct?
That's what it says in the quadro. Yes.
Okay, but that's actually not what was said. It was after there was let me pull up the mediated settlement agreement. I'm going to show you what I've marked as R1.
Well, I do have an objection. The mediated settlement agreement was subsumed in the decree. We spent months and thousands and thousands and thousands of dollars litigating this exact same issue in the last hearing. The quadro that they have signed and have submitted e-filed to the court says $150,000. So I do object to the MSA.
So, Judd, I think
Actually, this whole line of questioning, we've litigated, they spent $20,000 on Larry Bradford in the last case. We had to litigate all this then. And we don't need to relitigate it.
this is not relitigating, Judge. This was one of the issues in this case in particular, is how the divorce decree is drafted and how the quadros were drafted thereafter. Specifically, the divorce decree failed to mention the date of division of the quadros in there. It just says she's awarded 50%, he's awarded 50%. It doesn't say as of the mediated settlement date of November 3rd. We're gonna have to do a nunc on that. In addition, the quadros didn't have that. I had to get with Mr. Turner to add in that the evaluation date is as of November 3rd, 2022. That was added in. So then what's happened is the Janney fund, let me stop my share so I can see Ms. Williamson. The Janney shares, Janney. That is a fund that I've never had do this in particular. They are requiring not just the quadro, and this is where the fights come in. They're requiring on the TID that we specifically delineate the amount that has to be transferred. I have never had an agency request anything other than a quadro that says 50% as evaluation of this date. And so the fight has come down to the fact that Mr. Atkinson is unilaterally calculating what the percentage is. And if you look at the mediated settlement agreement, it specifically talks about how we draft the documents about when you look at property, what is awarded, and none of that additional language, for example. And I'll tell the court.
Well, so we're getting a little far afield over the issue of whether the MSA should be admitted. And I'm just going to go ahead and admit it. Our R1 is admitted. Mr. Turner may be correct that it ends up being not relevant to any issue, but for now, I'm going to go ahead and admit it.
May I add one more thing to the record, please?
Ms. Williamson says no, but I'm pretty sure that's not to, may you add one more thing? It's,
It may be for me.
Ms. Williamson, what's going on?
Just consistent crosstalk, and I know we've got time limitations that everyone's trying to adhere to, but it just makes my job almost impossible when we get to this point.
All right, let's work on not speaking at the same time as one another and speaking at a normal speed. Mr. Turner.
And I just want to point out that Petitioner's Exhibit 10, which is a proposed order that's been e-filed by Respondent under Section 5 of it, it specifically says 50% of Janie Montgomery 8142 after $150,000 in Eric Atkinson's separate property. It says the same for 0469 after 65,000. That is a judicial admission, and that therefore they are stopped from taking a different position. And I do not have the burden of having to counter any of that. That is a judicial admission, and that's the end of the discussion. Also, as I said before, we litigated this issue with Judge Iserloh, and it's gone. Thank you, Your Honor.
So I see P10, and I see it's the transfer incident to divorce, which is TID, and I don't see a judge's signature on it. I do see both Mr. and Ms. Atkinson's signature. Is that correct?
Correct, Judge. And that's also the one that he is seeking to us to have us re-sign with a different amount, which is why it's important the court hears this.
That's not true. We're not asking that the quadro be redone. The quadro, the respondents e-filed. They have filed a document with the court that they have signed. That is a judicial admission, plain and simple. That transfer document I am asking to have corrected.
I can respond to actually those specifics, Judge, because I think that's not accurate based on the drafting of the actual language in the quadro that refers to as of the effective date, which is November 3rd, 2022.
So that is what I need to see. So that's part of P10. That's
Yes, it was on page 3 of 7 on P10, top of page 4. As a part of the just right division of the estate of the parties, the court awards, assigns, and grants to alternate payee the following participants account.
I need to stop you. I'm not sure what document you're looking at.
I'll pull up P10, Judge. Can you see this P10, Judge? The transfer to divorce?
Yes.
Okay. And so let me show you what the quadro says, because this is where the argument comes down to. It says we had to define the valuation date. This is what we had to add in. Valuation date shall be defined as the date the parties signed the MSA, which is November 3rd, 2022. And yes, we put in the valuation date or valuation of 150, but that was as of the valuation date. So that was correct. That's not incorrect. That was as of the valuation date, the 150,000 was his separate property. That's not the argument. The argument is he takes that with all gains and losses for the TID, and that calculation is incorrect.
So, what calculation are you suggesting should have been made?
Yes, Judge, the calculation should be the total account value at the time of the MSA. And
November 3rd, 2022?
Correct. And then from there, we divide out to figure out what percentage the separate property claim was. And then apply that separate property calculation percentage to the current balance to determine what is the remaining community property that is divided 50-50.
So just for example, using round numbers, why don't you give me an example?
Okay. So if we say the account balance at the time on November 3rd was $300,000, and we're just using for argument purposes, Judge. And forgive me, I can't do math in my head anymore. So, and he had of that 300,000, 150 was separate property at that time. that would mean he would have a 50% interest that was separate property. And the remaining 50% would be community property divided in half. So applying that formula, that's probably a bad example, but 50% would be multiplied by the current value as of what it is today, because Janie requires specific amount of funds to be transferred. And then that remaining 50% gets divided in half, and that is the value that goes on the TID to transfer to Miss Atkinson. But I think that's how they need to be calculated. And that's why I went back to the MSA, because the MSA, even when it's assigned to him on the spreadsheet, it says together with all gains and losses on his separate property.
All right, I understand. Mr. Turner, you may continue.
Thank you.
I think it was, I'm sorry.
She had passed the witness.
Oh. Yeah, I think you were. Ms. Locke, do you think you were up or he was up?
I think I'm still up, Judge.
Do you agree, Mr. Turner?
I thought she passed the witness. I could have sworn I heard I passed the witness.
I don't think I did, but so let's go ahead and let her continue.
Okay.
Thank you. How many times have you asked Miss Atkinson to provide the information relating to her psychiatric care?
I don't recall.
Okay. And can you point out to the court where in the decree it requires her to provide documentation relating to that?
There's a provision that says with confirmation to the other party.
Mm.
If I'm going by memory.
And where is that contained? Is that in the decree of divorce?
It is.
Here, you don't know whether she has been in compliance. Is that right?
Well, I only know that she testified in court last time that she's never been to a psychiatrist.
Okay. And are you aware that there's an Adderall shortage in the country?
No.
Okay. Are you aware there's a Vyvanse shortage in this country?
No.
You're not aware that there's been a problem getting ADHD drugs for people that need them in this country recently?
No.
Okay. How much is a receiver going to cost? Do you know if the court appoints one for the house that Miss Atkinson resides in?
I don't know. As I understand it, they're on a time and materials basis is what it's been explained to me.
Okay, you'd agree that would substantially reduce the amount of monies that my client receives. Is that correct?
For both of us, yes.
Okay. Well, how much is it that she makes a year, Mr. Atkinson?
I don't know.
Well, how much do you make a year?
Last year I made $340,000.
Okay. And you would agree with me, you make substantially more than Miss Atkinson. Is that correct?
Yes.
Okay. And you've had the ability to pay for everything related to the divorce, correct?
Yes. Yes.
All right. And in fact, so much so that you're able to still offer to buy one of the houses from Miss Atkinson, correct?
Yes.
Okay. And yet you are asking that she be put out on the street, correct?
No.
Well, you're asking a receiver to be appointed and her be removed from the house, right?
Yeah. Well, I don't know what the receiver is going to do. I think the receiver is going to help us get the house sold.
Okay. You would agree with me. You want her out of that house. Isn't that correct?
What I want is to execute the components of our divorce.
Okay. So objection non-responsive.
Sustained.
You want her out of that house, don't you?
No.
Okay. So you're okay with her remaining in the house during the pendency of the sale. Is that correct?
Provided we can successfully get the house sold, I have no issues with that whatsoever.
Okay. And why did you not sign the contract on the sale for Cypress Knee when it was offered to be purchased by someone else?
Because the kids are really happy here. This divorce has been chaotic, and I'd like to provide some stability for them.
So you're trying to look like the better parent because Miss Atkinson is not in the same financial position as you. Is that right?
Objection argumentative.
Overruled.
You can answer the question.
Can you repeat the question?
You would agree with me that you're trying to present yourself as the better parent because you're able to provide stability for the kids and Miss Atkinson's not in the same financial position as you, correct?
No.
Okay. Would it make more sense for both houses to be sold to third-party individuals at the highest possible price?
Not sure I understand your question. Certainly, we've been working to sell the houses, and that's been a challenge, as I think we both heard from the Realtor.
Okay, but it's been a challenge on your end as well, too, correct?
With Cypress? Sure, yes.
I'm gonna back up. All right, you are seeking to hold Miss Atkinson in contempt for failure to sign the TIDs, even though you're asking for new TIDs to be signed. Is that right?
Yes, ma'am.
And you think that is reasonable?
What I think is reasonable is to get the retirement accounts divided.
And you would agree that Miss Atkinson paid the $6,975 in attorney's fees, correct?
Yes, she did.
Okay. And do you have any evidence other than your spreadsheet that shows that she has refused to allow the children to call you?
Yes, Michelle Shaw's note.
Okay. And other than that note, do you have any other evidence?
No,
Okay. You would agree with me that you put in conditions with regards to your contract for the sale of Cypress Knee, correct?
I did.
And what were those conditions that you put in?
Assumption of the existing loan is kind of the main condition.
Well, there was more to it, wasn't there, Mr. Atkinson?
I don't think so.
Okay, well, let's pull it up. You didn't ask that there be additional agreements of immediate distribution of funds?
Oh, I did.
Okay, you would agree with me that that issue is hotly contested between you and Miss Atkinson with regards to what are the reasonable funds that should be paid, correct?
Yes, I do think that is a difference of opinion. Yes.
So it makes it almost impossible for Miss Atkinson to assign a contract for that sale to you because you all can't agree on what comes out from those proceeds, correct?
Well, I think that would be any sale.
Okay, well, let's look at the issues. These are the only provisions that exist with regards to the sale of those residences, right? And we're on page 42 of the final decree, right?
Don't recall exactly how the language was spent out and so forth.
Okay. Well, this is what it says. It's 4 paragraphs, right?
Maybe. I know there's a provision in there where I'm responsible to pay all the fix-up costs for the sales and then be reimbursed for those funds.
Okay.
I don't
So
know if that's contributed or not.
all it says for Cypress Knee is that you'll be reimbursed for required repairs, correct?
Yes,
You would agree with me that you and Ms. Atkinson have a disagreement about what the required repairs were, correct?
I don't know. Candidly, I don't know.
Okay. And you all have a fight over what even the carrying costs are, correct?
I don't know. I know that was a big challenge in the mediation, but I didn't hear what your position is.
Okay. But you would agree with me that we have a dispute even as what the carrying costs are for Magnolia Ridge, correct?
Okay.
Was that a yes?
If you're saying we have a disagreement, then I think that's an accurate statement.
Okay. But yet your offer to Miss Atkinson was that she basically accept your deductions and then agree to buy out the Cypress Knee house. Isn't that correct?
Objection, that completely mischaracterizes the contract. The contract speaks for itself.
So I'm going to overrule the objection. You may answer the question.
I want to answer the question in the most informative way possible. I collaborated directly with Jacqueline to make sure that my offer was equivalent to the other offer and that neither Jacqueline nor Alice was financially hurt in that transaction.
I'm trying to pull up the contract, Judge. Just give me a second. You heard Ms. Jacqueline's testimony that the paragraph that you were asking her about, your attorney was asking her about, she couldn't articulate to, right?
Yes.
Okay, so she didn't understand what that language was in comparison to what the offer was, correct?
Okay, yes.
So she didn't understand whether those terms were fair, correct, Ms. Atkinson?
Yes, I did hear that.
All right, so R13.
I've got it handy if you want me to share
No,
it.
I have it.
Okay.
No, it's not 13. Never mind, Judge. I'll just move on. I pass the witness, Judge.
So this is the contract that you offered. It's P17. And here we are on special provisions, paragraph 11. So the language that Ms. Locke was asking you about says the undisputed portion of the proceeds shall be distributed on March 14th. So if there's $200,000 that's not in dispute over the reimbursement, that gets paid to the parties right then. Is that correct?
That's my understanding.
If it's the entirety of the 500,000, which of course is not, but just for example purposes, that would be paid right then, correct?
That's my understanding.
And so you have an idea as of today, at least, what the, well, you have an understanding of what the reimbursements you're claiming are for Cypress, don't you?
I do.
Would you still believe there would be a significant distribution, even withholding that disputed amount? Do you believe there would be a significant distribution made on March 14th?
I believe it would be $100,000 or thereabouts.
Okay, I'll pass the witness, nothing further.
$100,000 to each of you or 50,000 to each of you?
100,000 to Miss Atkinson.
Thank you. Ms. Locke, anything further?
No,
All right.
Judge.
I see that Michelle Shaw is in the waiting room.
She'll be very short witness, Judge.
Okay, we'll let her in.
And you're Dr. Shaw, right?
Correct. Thank you.
Okay. Will you please state your name for the record?
Michelle Shaw.
And Dr. Shaw, we're going to just cut to the chase. You've seen these girls, correct?
Correct.
Okay. All right. How often do you see them?
Kind of sporadically. Lately, Gianna every couple of weeks and Bianca about every couple of weeks as well.
So we're having problems with your audio. It lagged. I'm going to go ahead and turn off my microphone, and I'm going to ask Mr. Turner to do the same. Sometimes that helps improve the quality of the sound.
Changes.
Dr. Shaw, are your observations with the girls that they both have good relationships with both parents? Do we want to try Judge without her video on? I mean, I don't, whatever the court wants to do.
I'm going to mute myself. I see Mr. Turner's muted. Let's just see if that helps.
Okay. All right. Dr. Shaw, I'll go back again. Do you observe both girls to have good relationships with both parents?
Yes.
Okay. Have the girls expressed to you any concerns about either parent not allowing them to talk to the other parent?
No, the girls have expressed that they don't have devices to contact the other parent easily.
Okay. And do they say devices at dad's house or mom's house?
Moms.
Okay. And that's because they don't like the phones that mom's provided, right?
And SIM card issues.
And other than that, your understanding is this Miss Atkinson has provided devices to them.
That's my understanding.
Okay. Do the girls seem to be happy, well-adjusted kids considering what
Yes.
they're going through?
Yes.
And Miss Williamson, our court reporter, is struggling today through our fault only. But any red flags or concerns that you have with the children and they're talking to either parent during either parent's care?
No, not at this time.
And the girls just complain about SIM cards and some technical difficulties, right?
Correct.
All right, I pass the witness.
Mr. Turner, do you have any questions for this witness?
Just very, very briefly, Your Honor. So, Ms. Shaw, I've have P006, which is your letter, already been admitted.
Correct.
And do you see where I've highlighted it?
Yes.
So it says in the most recent sessions, the girls have made the statements. My mom wants me to let you know that I can call my dad. You see that?
Yes.
Now, would that look and sound like coaching to you?
Yes.
Would that look and sound like talking about litigation with the children to you?
I don't, not necessarily, no.
I'll pass the witness. Thank you, ma'am.
Just a few follow-ups. Do you have any reason to believe with your sessions with the girls that they aren't communicating with dad?
They've
Doctor?
told me that they're not communicating with dad.
Okay, but they have told you it's related to device issues, right?
Correct.
Okay, and they have not made any indication to you that mom is prohibiting them from doing so, right?
Correct.
Do you see the kids when they're with dad as well?
Yes.
And you also see them when they're with mom, right?
It's more often with dad, but yes, mom has brought them in.
And so then when they go with dad, they're free to tell you whatever they want to about whether mom's behaving bad or not, because dad's bringing them, right?
Dad doesn't stay in sessions with me.
Okay, I understand that, but if he's the one that's majority bringing them, they're not expressing any concerns to you about mom being a bad actor of any kind, right?
I don't understand what you're asking.
Sure.
Being
Are
a
they-
bad actor?
In prohibiting communications with dad.
No, they're not.
All right, I pass the witness.
Nothing further, Your Honor.
Thank you, Dr. Shaw. You are excused.
Thank you.
All right, where were we?
Well, I think that we're kind of winding down. I know they subpoenaed Mary Alvarez, and I would call her, but I'm not sure I know how to reach her.
All right. Are y'all planning to call her, Miss Locke? You're on mute.
I'm checking. I was planning on calling her, I just don't know if she's still available.
All right, why don't you,
She is available. Let me ask right now. Oh,
okay.
she's available until 3, so we can get her on.
All right, is that what you want to do next?
I don't know. The court-
Mr. Turner, did you want to call her?
I think I'd like to call her, if I may, please.
All right, if
Thank you.
Miss Locke, if you're already in touch with her, just ask her to log in.
And so, Dr. Alvarez, you testified in the last hearing, did you not?
Yes,
And you had testified to replace Dr. Ainsley's recommendations, correct?
yes, in part, yes.
Correct. Now, to be clear, Dr. Ainsley had been court ordered to perform an independent psych evaluation on Miss Atkinson, correct?
Yes,
And you were not court ordered, and instead you were independently hired by Miss Atkinson to be her therapist, and you did write a report, correct?
yes,
So your report, you created a status update. And if you look on the screen, you'll hopefully be able to see what's been marked as P5. Is that with my notes and such, is that a copy of the status update?
yes,
I've asked that this be admitted.
Judge, I object because it has commentary from someone else that should not be on there. I have the clean copy of that version as my R9, which is fine, but I'm not agreeing to one that's been redacted or modified.
Yeah, I just had my notes, and that's fine. We could use a different version.
Yeah, I
So,
don't
ma'am, on the second paragraph, you start with currently, Miss Atkinson is not exhibiting. You see that?
yes,
Now, isn't it true that there certainly have been times in Dr. Ainsley's report, and certainly suggestion your original, that there were times she was exhibiting? criteria for delusional disorders.
I'm not sure exactly what you're asking, the way that you asked it.
And Judge, can we go off live stream for this? This is one of the kids' phone. This is Bianca's phone, right?
Yes,
And it shows the same type of information of incoming and outgoing, right?
yes,
And it's all the calls this phone number has received from in January during this particular time frame, right? The 15th through the 23rd.
correct.
All right. Judge, I move to introduce R18.
No objection.
R18 is submitted.
And so the court's aware you printed this out on 2/24. So this month you printed this out, right?
Right,
And you ran the information. Your request was 1/15/2024 to present, right?
right.
Okay. And on this, it only shows 3 attempts for Mr. Atkinson. Is that correct?
Correct.
Okay. Would this be different from what he's testified to in court?
Absolutely.
Okay. How often is he actually reaching out to the girl to the best of your knowledge?
I have 0.
Okay. Has he ever called your phone to say, hey, I can't get a hold of them on their phones. Can you have them call me?
No,
How many times has he sent you OFW messages saying, I can't get a hold of them on on their phones. Can you have them call me?
none.
Okay. Are you in compliance with your doctor's recommendations with regard to your ADHD?
Yes,
Is it a psychiatrist?
yes. I talked with the assistant. I've never seen a psychiatrist per se, so I only see an assistant, and they talk to the psychiatrist for the prescription, and I have to take it as I need it. If I don't want to take it for a year, it's my option. It's as needed. That's how they prescribe to me.
The term is PRN, is that right?
PRN,
Does the prescription say you were to take it PRN?
as needed.
And you are seeing the nurse practitioner for your psychiatrist, correct?
Correct.
Okay. And has there been an issue? Are you prescribed Adderall or Vyvanse?
Adderall.
Okay. And have you had a problem with obtaining Adderall in the last 12 months?
Yes, they are on back order the last time that I asked for it.
Okay. And how long ago was that?
It was about a week ago, and I just found that I needed because of the court, so I could focus more, but it's only if I need it. And I thought today would be a good day to take it, but they are on shortage.
Okay. And let's see, you've paid the attorney's fees, correct?
That's correct.
All right. And you are following Dr. Alvarez's recommendations, right?
Yes,
Are you refusing to allow the children to call their dad?
absolutely not.
Okay. And you signed the quadros once the date of the valuation was added in on that November 3rd date, is that right?
Yes,
The quadros that you'd been presented before did not include that valuation date, did they?
no, they did not.
Okay. And it was only after I came on board and said we needed a valuation date did they get added, and then you subsequently signed it, correct?
Correct.
Okay. Are you asking the court to deny the relief sought by Mr. Atkinson?
Yes,
Okay. Are you asking that the court issue orders requiring you all to follow all the realtor's recommendations with regards to the sale of the houses?
yes.
Okay. And you had concerns about signing any contract with Mr. Atkinson, is that correct?
Yes.
Tell the court why.
Everything comes with some underlining on it. There is always a trick. Like the decree, now they are asking me to, the decree now says that I have to pay for all whatever they fixed on Magnolia and Cypress Knee, and that wasn't mediated. And I never agree with that. It wasn't at the first drafts of the decree. It was included at the end after, everything was, going to court, it was just added that. And I know that because I printed out, I had it printed out the other drafts and I compare that to the other drafts, and it wasn't there that I should pay for Cypress Knee. I personally don't think it's fair that I should pay for both property. Example,
You don't think it's fair for you to pay
100%, yes, for fixing up both properties and splitting the profits. I think we should split.
You understand that the contention is that Mr. Atkinson should be repaid for what he paid off the top of the proceeds. So it's not you paying it, it's the proceeds repaying whoever spent money to improve the house before it's sold.
Yes, I think we should split. When I give him his part, I should pay 50% because we're going to split whatever is the profit. So I think it would be fair for us to split also the cost. So now he's paying 100% and then he's expected to be reimbursed 100%. But the property belongs to both of us. So I think that we should, when I give him his amount, it should be 50% of all the cost is.
Okay. Do you have trust issues with Mr. Atkinson and his dealings with you?
Yes, I do.
Okay. And is that why you've got concerns about selling the house to him because there's still unresolved issues relating to reimbursements? Is that right?
Yes, about the reimbursements. And also there's a lot of contingencies. And the other offer was there was not a lot of contingencies, but his offer has a lot of contingencies. And I just didn't think he was going to follow through since it took 10 months for him to list the property.
I pass the witness, Judge.
So, ma'am, I think you just said that the provision on the reimbursements to Mr. Atkinson were not part of the MSA and they were snuck in, right?
The Cypress Knee repair costs.
Okay, so do you understand that Mr. Atkinson is to pay all of the carrying costs for both Magnolia right now, correct?
Who is to pay? I'm sorry.
So Mr. Atkinson is paying the carrying costs for Magnolia, right?
He's paying for the cost and I will pay for the carrying cost. Is that right?
Well, let me ask it this way. You're living in Magnolia.
Mm-hmm.
And that'd be yes for the record.
What?
Right.
I'm sorry.
You need to say yes or no and not or.
What's your question? I'm sorry. What's the question, Mr. Turner?
You're currently, you're living in the Magnolia house, right?
Correct.
And you've been there without Mr. Atkinson for 2 years, right?
Correct.
And what, as far as the Magnolia house, have you paid in the last 2 years?
No, I just got the bill.
I'm sorry?
I haven't paid. I have a bill to pay, but I haven't paid.
Right. You haven't paid anything, correct?
Correct.
So Mr. Atkinson pays the mortgage, which is the principal and the interest and the taxes and the insurance. He pays that every month, right?
Right.
And he pays the electric bills and everything else, right?
Correct.
And so the agreement was that he would continue to pay those until the house sells, and then he would get reimbursed for those items that he paid. Pretty simple, right?
Correct.
So you would agree with me that the contract that Mr. Atkinson tendered to you is the same net to you before expenses and reimbursements as the contract you would receive from Ms. Mendoza, right?
I don't know for sure. I just know the contingencies.
So you don't want Mr. Atkinson, let me scratch that and start that over. You're refusing to sign Mr. Atkinson's contract offer on Cypress, correct?
I sent it to my lawyer and we were going to analyze, and there was a lot of contingencies. That's what I know.
Okay, and I'm going to object that was non-responsive.
I think it was responsive, Judge, but.
Well, the question was whether she's refusing to sign the contract. So let's ask it again.
So, ma'am, you're refusing to sign the contract that Mr. Atkinson tendered to you, correct?
Correct.
And the reason is because
Payments of an assumption fee in excess 1,000 on the loan assumption terms loan assumption term addendum to contract concerning the property.
I'm
At,
not understanding. I'm sorry, Judge, I'm not understanding the answer.
Let me ask a different question if I may, or ask it slightly differently. Your lawyer was asking Mr. Atkinson about the same issue, that Mr. Atkinson wanted to buy the house so he would feel like he was, and look like he was the better father, better parent. You would rather kick your kids out of that house than have Mr. Atkinson stay in that house with those kids, wouldn't you?
I would love for him to buy the property.
Is there any, can we just agree then with, ask the judge to order you to sign this contract as it is?
Judge, he's trying to contract with my client. It's not an appropriate question for him to ask.
If he removes all the addendums, all the assumptions, like if things doesn't go the way that he wants to go, so then the sale is off the table. I forgot the word, how to describe that.
Contingencies.
Contingency, yes. If he remove all the contingencies, I'll be happy to sign.
Well, and so that begs a different question, and it come up in earlier testimony. The party said agreed at one point that you were going to buy Cypress.
Judge, I'm going to object to anything that relates to settlement negotiations that occurred at mediation.
They already
Sustained.
testified, they already brought this up with Jacqueline Foreman. They opened the door on this with Jacqueline.
Well,
Foreman.
I'm told that you have 2 minutes left, Mr. Turner, of your time. So
Does that include closing or no?
What's the question? Sorry.
There is no question. So let me just ask in my 2 minutes, the kids do not have Apple phones, correct?
Not in my house, unfortunately.
Okay, and then you had mentioned that Mr. Atkinson had not contacted you in some time to ask about the kids, be able to call the kids. And there's been litigation over this issue for ongoing for almost a year, right?
Right.
Okay, and what's the name of your psychiatrist?
Sweet.
Okay, and the one
I'm sorry, I didn't catch that name.
Dr. Sweet.
confirming that you've ever seen talk to Dr. Sweet or anybody in his office.
It was provided at the last court hearing.
Ma'am, actually, your testimony at the last hearing is you didn't have a psychiatrist.
I think I have it since 2018 for ADHD. I don't see the psychiatrist. I see the nurse practitioner. I don't know if that's what you're implying.
I'll pass the witness, Your Honor.
No other questions.
All right. Do you have any additional evidence you need to put on, Ms. Locke?
No, Judge.
All right. So you close and rest and
Yes.
close.
Yes,
And you
Your
do
Honor.
as well, Mr. Turner.
The petitioner rests and closes. Oh, other than our attorney's fees.
All right. Well,
Yeah.
I'm ready to make some rulings, and I'll
Okay.
tell you, I find this all very frustrating. The pattern of repeated litigation to try and get these parties to where they need to be is a problem. So let me just say, I'm not appointing receivers to take over the sale of either property. But I am going to require that both parties comply with the recommendations of their chosen realtor, who we heard from earlier today. And her name is Jacqueline Foreman. And to the extent that they cannot agree, they need to comply with her recommendations. So if she says that the two contracts on Cypress are equivalent, then Mr. Atkinson should be able to buy that property. And I'm talking about equivalent financially for Miss Atkinson. On the Cypress house, I'm sorry, that is the Cypress house where he lives. On the Magnolia house, I am gonna order and this will go for both houses if the sale doesn't go through on Cypress, that if the realtor requests a showing, then whoever's living in that home needs to either agree to the date and time or propose another time, which would be within 24 hours of the date and time requested. And they must call back if there's a message left about a showing and the realtor does not reach you. That callback needs to be made within, let's say, 3 hours of when the message was received. So there should not be any times when a person wants to view the house and that viewing doesn't occur within 24 hours. If the realtor is requesting repairs or other things be done in order to sell the house, that needs to happen as well. And it sounds like this water leak at the Magnolia house, has it now been repaired?
It has.
Right.
Well, my understanding, there's correspondence on OFW that he is sent over plumbers. If they are not, then we will figure it out with, I'm sorry.
The plumbing has been repaired. The damage to the deck has not.
All right, well then that needs to happen. That needs to happen, let's say by the end of this month. And so that needs to happen with Mr. Atkinson paying for it and with Miss Atkinson making arrangements for the workers to be in her house. About the phones. The girls need Apple phones, not flip phones. Because I haven't heard any argument that it's a financial issue that has caused them to have flip phones instead of Apple phones. Y'all decided they needed 2 different phones, one at each house. I don't really understand that, but if that's what y'all want to do, Miss Atkinson, if you're willing to let them bring their Apple phone from Mr. Atkinson's house to your house, then you don't need to buy an Apple phone. But if you need to have a different phone for each girl at your house, then you need to go buy an Apple phone. Doesn't have to be the top of the line, newest Apple phone, just needs to be an Apple phone. That needs to happen by the end of this month as well. There's an issue about scheduling, about calls. I need y'all to reach an agreement on how often the girl should either text or talk to the other parent when you're at one parent's house. It should be equivalent. So if the answer is there needs to be at least 1 text a day, that will go both ways, or 1 call a day of a particular duration. If you all can't reach an agreement on what that ought to be, then you can send me your 2 proposals and I will choose one. That needs to happen by the end of this month as well. As far as the issue about the transfer documents on the 2 retirement accounts, is it just 1 that hasn't yet been signed, or is it 2?
There are, 1 has been signed, but they're asking for it to be changed. And then the other one was not signed because I had asked Mr. Turner to verify how his client had come up with the amount, but those are the 2 that are an issue.
I am persuaded that the method that Ms. Locke proposed on how to come up with what amount got transferred is the correct method. And that is, as of the valuation date, what percentage was separate property, and then applying that percentage to subtract out the separate property and dividing the remainder in half. That needs to happen by the end of this month and needs to be signed within 2 days of receipt. Date and time for Mr. Atkinson to retrieve the items. y'all shouldn't need to come to a judge to do this stuff. This is crazy.
Oh.
Y'all need to come up with a date and time for him to come to the house and get the items. There's a list of the items for anything that he can't find at that date and time, then he's going to need to be paid for the missing item. But there needs to be a date and time for him to retrieve the item, and that date and time needs to happen by the end of this month.
Yes, Your Honor.
For clarification purposes, that's in reference to the exhibit. Let me make sure I get the right number. P13, P013.
Correct.
Thank you.
With all due respect, I do have a question.
No, we'll
Okay.
talk later.
All right. To the extent that there are items on that list that the Realtor indicates in writing need to remain in that house for staging purposes, those need not be returned until that house sells. But that needs to be a written recommendation from the Realtor before it can be withheld. If there comes a point when the Realtor is asking to drop the price and you all do not agree to drop the price, if both of you agreed that the price should remain the same, the price may remain the same. If one of you agrees and the other disagrees, the Realtor is the tiebreaker. Other than attorney's fees, did I leave anything out?
The psychiatry. The following recommendations. That's the only language issue.
So, what I heard is that she is following the recommendations of her psychologist and seeing her regularly, and that the psychiatrist's requirements are that she take the ADD medication as needed, and of course, as a practical matter when it's available. I think she is following that recommendation, if that is in fact the recommendation. So here's what I would say about that. She needs to get a letter from her psychiatrist saying what the recommendation is, and the psychiatrist's assessment of whether she is following the recommendation. She needs to get that letter by the end of the month. And that needs to be provided to Mr. Turner. Anything else that I missed?
No,
besides attorney's fees?
No, ma'am.
I just want to make sure, Judge, that that letter doesn't get disseminated or used in any way other than for purposes of just satisfying the requirement. I don't need it being distributed by any of the parties.
Correct. There's still HIPAA considerations. They don't get to show any of these medical or mental health issues to anybody. They're solely for the purpose of complying with the decree. All right. On the attorney's fees, I am going to defer the question of whether one side or the other should pay attorney's fees until I see whether or not you all have complied with the requirements that I just laid out today. But let me just say this, and I assume this isn't something that your lawyers and the judges who've presided over various parts of this and the mediator, all of them have probably already told you this. But I have no doubt you both love your children and they love both of you. I have no doubt that you want them to grow up to be well-adjusted, happy, healthy kids and adults. Y'all need to stop fighting, or that's not going to happen. Your fighting has an impact on them. And the fact that the kids go to a psychologist and tell them, Mom wants me to tell you that she lets me talk to Dad, that is an indication, as the psychologist said, of coaching and of including them in your disputes. Y'all need to stop doing that. And specifically Miss Atkinson, you need to stop telling them what to say to their therapist. But generally, the two of you need to find a way to get along for the benefit of your kids. I understand you're divorced because you couldn't get along. I understand that you've got both of you legitimate reasons why you have trouble getting along. But you need to set those aside for the benefit of your kids. Because at this point, what you all want from each other has to take a back seat to what your kids need from you. And that's all I'll say about that. All right. When can you get me a proposed order, Mr. Turner?
I can get something to Miss Light by certainly by Wednesday.
That's
All
fine.
right.
I'll get it whenever the court tells me to get it back. I would like a copy of the order from the court from Miss Williamson as well.
You mean the transcript of what I just said?
Yes, Your Honor.
All right. So I'm going to say if I don't have an agreed to form order on February 29th, 2 weeks from today, then we're going to schedule a hearing on a motion to enter or cross motions to enter for looks like the only Friday I can make it happen would be Friday afternoon, March 8th. So y'all either need to have an agreed to form order to me by the 29th of February or by the morning of the 4th, your proposed motions to enter.
Judge, can that entry be virtual?
Yes.
Okay, because I'm going to be on vacation. No problem, I'll do it. I won't. Anyways, if it's virtual, that'd be great.
And
All right.
I'll actually finally be in Austin on the 8th, so I'll still virtual it, I guess.
All right. And we will take care of putting that on the docket and calling it announced. So y'all don't worry about that.
Good. Thank you, Your Honor.
We'll
Thank
do it. We'll have that tentative hearing set at 2:00 on Friday, March 8th. And I'm hoping that we won't need it, but it will be a virtual hearing.
Thank you, Judge.
All right. Thank you all.
No, I had a question. I have my hand raised. Do you see it?
No, now I do.
I just wanted to remind council that you need to upload any exhibits that needed to be redacted. I didn't want y'all to forget that. So
And
just
call them redacted, and then Michelle will delete the unredacted versions.
Okay, easy enough. Thank you very much. May we be excused?
You may.
Thank you, Your Honor.
Judge.